Good morning. I'm Michelle O'Neill with O'Neill Wasaki, and this is our Webinar Wednesday. Today we're going to talk about child support. We're going to tell you about some child support war stories and go through kind of the basics of child support law in Texas. So the first segment that we're going to do is going to be on setting child support. We're going to talk about computing net resources, the new cap on net resources, and some of the interesting issues that come up in setting child support. The second session that we're going to do is going to be on enforcement of child support. A lot of issues come up with enforcement of child support orders, and I'm sure you all want to know all about it. So we're going to talk about that in our second segment. Our third segment is on UIFSA jurisdiction, the Uniform Interstate Family Support Act. And then we're also going to include medical and dental support in that section. And our fourth section is going to be what happens when the Office of the Attorney General gets involved. And that'll be an interesting segment for everybody to hear about. I am joined today by Jennifer Sadegh and Erica Atkin and Brooke Fulks with my office. Erica is formerly with the Office of the Attorney General in Kansas, and so she has a little bit of insider information for us about how that OAG thing works. So I am excited to share this with you, and I hope you get a lot out of it. Remember that we are approved for 2 hours of CLE credit here in Texas. If you register with the Eventbrite link and pay the small little registration fee of $20, then we will automatically submit that for credit for you. The credit is good for a year, so even if you don't watch us live, you can still watch it after it's over, and then you can get the credit. All right? Sounds good? So stay tuned. We're bringing it to you in just a minute. All right. Feel good? Yeah, it's fine. If you can edit out that one little blurby.
Where should I be looking?
This camera right here is ours. That one's theirs.
But you can pretty much just pretend that you're there. Just look at each other.
Yeah, when we're all four talking, we can look at each other. I mean, for me, I'm like, do I need to do the disclaimer, or are you going to include the disclaimer that we did before?
I always run it at the end.
Okay, good. Good. I don't like having to redo that one.
Yeah.
Remember, this is not legal advice.
I've heard that a million times.
We'll let you recite it at the end. Like movie.
Yeah, Kevin's a radio guy. He probably could do our disclaimer for us and be like, oh, yeah, you could just do a voiceover on it. It'd be like Michelle's mouth moving and Kevin's voice. That would be fun.
Like the side effects drugs guy.
Yeah.
Oh, yeah. Okay, whenever. Hold on, let me dial back my range there.
You want it?
Oh, no, I was saying I didn't bring anything with me.
Uh-oh.
Do you need some more?
Oh, no, not this second. We're fine.
Oh, okay.
We'll get it on the next break.
Half break.
All right, whenever you want to kick off section 1, you're good to go.
All right, awesome. All right, welcome back to this Wednesday webinar, sponsored by O'Neill Wasaki Lawyers in Dallas. I'm joined today by Jennifer Sadegh, Erica Atkin, and Brooke Fulks with my office, and we're going to talk to you about child support. So this first segment is on setting child support. We're going to talk about net resources, intentional underemployment, adult disabled child, like all those kind of topics. So let's kick it off and let's talk about, I always believe in when you start something, where do you start? You know where you start, at the very beginning. So let's talk about what is child support. What is it intended to be? How does it different than other types of support? Brooke, you want to take that one first?
Sure. So child support is intended to be paid by, generally speaking, the party that doesn't have primary possession of the children. And so in more circumstances than not, you have parents that one parent will kind of have that primary amount of time and the second parent has less than primary. And so it's generally that the parent that is not in primary possession is paying for support of the children. It's to help with food, to help with clothes, to help with just general living expenses, since that parent is not with the child primarily.
And how does it differ from other types of support, like, say, alimony?
Well, under the alimony, that's intended to pay your ex-spouse, whereas on the child support, it's intended to go directly for support of the children. The other elements now are that child support can be enforced by contempt, and we're going to talk about that a little bit later, so I'll hold off going down that rabbit trail.
Okay, so I know you've all had this question, but pretty frequently we get non-primary parents of both genders that come in and say, she's using my child support to get her nails done. I want an accounting.
No way.
So what do you say to that? Who wants to take that one?
Oh, I'll take it. A judge isn't going to order an accounting. They can use it however they want, just like the money that's paid for child support goes towards part of the mortgage or part of the rent. I mean, it's not something that a judge is going to say, okay, I'm going to micromanage and expect you each month to provide a list of all of your bills and expenses to the other party. And like the 12 years I've been practicing, I've never seen a judge do that. And then a comment further on what Brooke said earlier, there is another situation in which both parents could be ordered to pay child support if, say, a relative or a third party is the one that has primary possession of the child or children, and therefore the parents have a duty to support the child. And so the court would order both the parents to pay child support.
Okay. So moving forward then, how do we set child support, Erica?
So we start by calculating the gross income, and I believe the statute says that you need to start by calculating the annual gross income, and from that, if you're able to calculate the annual income, then from there, calculate the average monthly gross income. After that, you take the gross amount and you calculate the net resources, and I believe it's Texas Family Code 154.062 that defines what all is the net resources. So there's a bunch of things in there. The big ones are all income, any kind of wage, salary, anything like that. But there's all sorts of other things. There's pretty much everything except for return on principal or capital, accounts receivable, and then TANF, which we'll talk about later when we talk about the OAG section, and payments for foster care of a child. And all of that is taken into consideration, and then you apply the guidelines to that. And there are situations, when we can talk about that more, when the guidelines might not be applicable, and then as well as the cap. And from there, you get your
Child support.
the child support amount. Yes.
So, okay. So let's break that down. So let's say that I have a job and I get overtime. Does my overtime count in my net resources?
Yes.
Are you sure? I mean, my overtime isn't the same every month.
It's still a part of your income, and that's where taking an average is going to come into play, because if your overtime's not the same, you want to look at a bigger scope of time to figure out how much on average in overtime are you getting.
So how far back in time do judges look to determine what the average net resources are?
I'd say a year, because the statute says to look at an annual amount. If it fluctuates over time, there is case law somewhere to say that, I think it's Swab v. Swab, I wrote it down, 282 Southwest 3rd 519, where the court has authority to average income over a greater period of time. I believe in that case the individual was self-employed, and the self-employment income fluctuated from maybe $10,000 in a year to $300,000 in a year. And so the court took an average over many years. So I think the court's going to take into consideration the circumstances of the situation and how much fluctuation there is and over what period of time.
But Erica, going forward, I'm not going to get the same amount of overtime, or maybe I'm not going to make the same amount of money. I'm a salesperson after all, and I don't make the same amount.
So what I would say to that is that child support's based on what you're making now, and that there are provisions for modification in the future if that becomes the situation. Although the modification statutes are pretty specific as to when you qualify for one, it's based on what you're earning now.
So child support is a current to backwards looking calculation then. Would that be an accurate way of saying it?
That's how I would describe it, yes.
Not a future looking.
Yes.
You're paying in the future based on what your past wages
Yes,
were.
because the same argument could be made that next month you might get a huge bonus and your income could go up just as your income could decrease. It's hard to predict the future.
Yeah.
I think we see that a lot, that a case will start and the parent who is expected to pay child support goes, oh, I'm gonna trick this up, and they stop taking that overtime. They stop taking, maybe they drop the second job that they've had so that they think in their minds that they're reducing how much income they have to lower their child support. And that's why it's even more so important, why the legislature plans for it to look backwards to see how it's averaged out over at least the course of the last year.
Yeah.
Well, and also in addition to overtime, commissions would be the same way that counts as income. The family code provides that an obligor would have the duty to provide his last 2 years or her last 2 years tax returns along with pay stubs. And so that's why you can make that argument of, yes, there's fluctuation, but I think from the court's perspective, you can definitely argue and have a good basis to say the last 2 years should be considered as well as current.
So a primary parent, obligee parent comes in and says, I think he's making cash under the table. What do you do about that?
You asked to see their bank statements.
And so how do courts look at if there's an allegation or a possibility that there's income coming from other than traditional sources? Like, how do you go about as a lawyer finding that, locating that, and proving that in court to show net resources?
So in the couple of cases I've had where we've done that, we've gotten the bank statements from the non-custodial parent to show sources of income, whether it was unidentified deposits or cash deposits, and then added that evidence along with testimony from my client of the fact that usually they have firsthand knowledge that, oh yeah, while we were married or during our relationship, he or she would, do odd jobs. They would get paid in cash. That's always how he gets paid. Or occasionally it's checks, so you can get copies of the checks showing the deposits. And then also, now that there's other ways to pay, Venmo or PayPal, you can get access to those records as well to basically provide that evidence to the court to come up with what the gross income is.
So before we started, you were telling about a case that you had about a car payment. Tell about that.
Yeah. So I was in the gallery at court in 40 Court in Dallas. So it was cases that judge hears day in and day out for enforcement of child support. And a man was explaining to the judge that he had multiple children with more than one mother, and that he just couldn't afford to pay the child support that he was ordered to pay. And, the judge said, well, the fact that you had additional children, maybe you should have considered that before you had additional children. And, this guy's pleading his case, kind of looking for mercy from the judge. And the first time I'd heard this, the judge says, well, let me ask you, do you have a car? Oh, yes, Judge, I've got a really nice truck. He said, oh, so do you have a car payment on that car? And he said, oh, yes, Judge. And I can't remember now, but I want to say it was about $600. And the judge said, oh, well, if you can afford to pay $600 for your truck, you can afford to pay $600 to support your child, because that's what's in the child's best interest. And I don't think he was expecting that to happen, but that's what the judge ruled, and he
that's
didn't have a lawyer, so.
That's perfectly within the judge's discretion to set it based on some other factors other than strictly a pay stub, right?
Right.
Yeah.
Michelle, there's a case that just came out in 2019. It's a MEMOP opinion out of Fort Worth that kind of deals with this issue where an obligor didn't produce documents in response to discovery, and so the trial court sanctioned him and prevented him from putting on any evidence to show that he made money under the cap. And so the Court of Appeals upheld that and said that because he failed to comply with the discovery, the trial court was within their authority to award the cap amount of child support for him. So I think part of that and following up and making sure you have that is having your discovery request in place and filing a compel if you need to.
Okay, so let's turn to what exactly are the child support guidelines. So Texas has kind of guidelines on how we set child support, and that differs from a lot of other states in how they calculate child support, right?
Yes. So to back up a little bit, the guidelines they come from the federal statute under the Social Security Act, Title 4D of that, which we hear 40 courts, all that. That deals with child support. And within those statutes, it requires states that are operating and receiving the benefits of Title 4D to have guidelines in place. But it leaves the authority up to the states to determine what those guidelines are. Having worked in Texas and worked in Kansas doing child support work, I can tell you that the guidelines are completely different.
Yeah. And they're different in every state.
Yeah.
Every state kind of has their scheme of how to calculate child support.
Yes.
So in Texas, we have basically percentages. And so if you have one child in one household, it's 20%. 2 children in one household is 25%. And it kind of goes up from there up to what's 45%? What's the top one? If you have a whole bunch of children. And then if you have more than one child in a household, so you have multiple households with children in it, then there's a little bit of a discount that goes, but not exactly a total discount based on the different children in different households.
Well, and unfortunately, if you're the non-custodial parent, you don't really consider it much of a discount because you can basically get tagged at, like, for example, 17.5% for each mother.
Yeah.
For each child. So
Right.
It ends up being,
Right. So, okay.
Quite a lot.
Yeah, I was trying to find that. So it caps out at 40% of the obligor's net resources at 5 children. And if you have more than 5 children in one household, then the max is 40%. And then whenever it starts looking at the multiple family households, then you get a little bitty, teeny tiny discount, and you end up paying a whole lot for both or multiple households. Really discourages you from having multiple baby mamas, right?
yes.
Assuming you know what the statute says.
Well, you know. So then you talked about the cap. So let's talk about what the cap means. So we have a maximum amount of child support in Texas that can be awarded under the guidelines. So what does that mean, Erica?
It means that if you're making money in excess of that amount, and it's actually just changed here as of September 1st, the cap is now $9,200. It used to be $8,550. That's presumed to be the maximum amount of child support that you pay, even if you were to make $1 million a year.
Right.
That's what it is.
Okay, so $9,200 is the maximum amount of gross or net income.
Net income.
So $9,200 net income per month multiplied by the percentage that applies to you is what we would call the maximum cap on child support, on guideline child support.
Yep,
Right.
that's correct.
So is it possible to get child support above that guideline?
Yes.
And what are the circumstances for that?
Go ahead,
The
Jennifer.
court's looking for the needs of the child, whether it's private school, medical needs, educational needs, learning disabilities, speech therapy. There's actually case law out there that it could even be something that's extracurricular activities. But basically, the court needs to see a need, and I think there's even case law that can kind of support if there's a really large disparity of income just based on the earning potential of the primary parent, to argue that that additional need is just to help cover living expenses for the household in general to support that child, because you also have the factor of the best interest of the child or children, which is kind of a very broad, subjective viewpoint. And something else that I think is interesting, because I often have non-custodial parents that bring this up, which is, well, my take home is only $4,500 and their gross is $7,000, and you look at the pay stub and they've got a huge deduction for 401k or other things that they're like, so this is my net, and Well, for purposes of calculating child support, your 401k or other retirement contribution is not
included.
counted.
Yeah.
There's a recent case, and I'm sorry I don't have it in front of me, but the child was autistic. Dad was already paying max guideline child support, but mom was having to drive 45 minutes to get the child to the proper school where he was enrolled that was helping him with his disability. And so between the driving and the full-time caretaking, the court ordered him to pay more child support because of the needs of the child, taking into account not only his autism, but also just the gas and the mileage and the time that mom was having to spend in addition to what she was already doing anyway. So the court is really looking at the best interest factors because of the public policy of making sure that our children of the state are being taken care of both by parents and then financially.
One thing that I think is interesting about the above guideline support arena is that, the cases are kind of all over the place on what the courts have the discretion to do, but they do seem to kind of agree on one, a little bit of a benchmark standard, that you can't just have it be any old need will do. Like, it has to be a special need. It can't be a luxury. It can't be a want. It can't just be that I want my children to go to this expensive private school instead of public school. There actually has to be some reason behind it. And I had a case recently where the child had some learning differences, not disabilities, but differences. And there was a particular school that was better for her than another school, better for her than a public school. And we, in that trial, we actually put on evidence about how that school was better. And that was a way that we were able to get the court to grant an allotment for the private school tuition, where normally a court cannot award private school tuition just straight up. But I think you have to put on a little bit extra effort and extra evidence in showing how that works. In that case, what we had to do was we had to first account for all of the child's expenses, like the portion of the rent, the portion of the car, the portion of the grocery bill, but then also, all of her extracurriculars and basically everything that went into how much this child costs per month. And then you allocate first to it the amount of the guideline cap child support. This particular obligor made significantly above guidelines. So you first allocate the max guideline child support to it. Then you have to allocate an amount for the mother, the primary parent, to pay an equal amount of guideline child support. And then the amount over that, the judge has to consider how to allocate that between the parents. And in our particular case, the judge awarded 100% of that over guideline amount to the obligor, to the non-primary parent. And that's within their discretion. They get to decide, are we going to split it 50-50? Are we going to do some other percentage? And in that case, the judge awarded 100% of that above guideline amount to the non-primary parent. So it's a very discretionary thing, but you have to go through and prove it up, because if you don't go through and prove it up, it may not stick, and then your client will be stuck with guideline child support. So okay, let's talk about intentional underemployment. How do you go about gathering evidence for intentional underemployment? Like, how do you try a case like that, trying to show that somebody isn't working hard enough?
I think we touched on it a little bit earlier by going back and looking at past earning history. I think Brooke touched on it in cases where people think they can fool the system by quitting their job, things like that. So looking at past employment, looking at their education history, what are you qualified to do? Then looking at what market rates for people in positions like that would be. But the big thing with that is that you have to put on very clear evidence that they would actually be able to earn that money, not just, oh, hey, they could maybe be an engineer and engineers could maybe make this amount. I mean, you've got to have specific evidence based on their actual work history and education background.
How would you go about finding that evidence?
I think obviously just written discovery is a good first step. What's interesting about child support in my experience is a lot of times when modifications especially, they've already fully litigated. They may have gone through the 1 to 2 year long case. they've expended a lot of resources. And so when they're coming back in for a modification and saying, hey, like he's intentionally underemploying himself, that primary parent, the obligor, the obligee, may not have the resources to do full-blown litigation, like do full-blown discovery. And a way to jump through all that and get right to the heart of it and get that person under oath is I would go for a deposition, honestly.
What about hiring an expert? I mean, are there job experts that you can hire that could talk about like potential, like take this person's qualifications and match them with a job and then testify about what they might earn doing that job?
Yeah, I would think so. You can usually find an expert for just about anything.
All right, then our last topic is adult disabled children. So to start this topic, like let's talk about when child support normally ends.
Child support normally ends at the later of the child's 18th birthday or when they graduate high school in most cases.
Okay. And so what happens when you have a child that has some sort of disability and can't can't get a job, can't move away from home for some reason? How is that handled by the courts?
So in situations with an adult disabled child, you're going to have to, one, put on evidence to the court that the child's going to need support going forward beyond that 18 or graduating high school. And as to what specifically that support is, it's going to require a little bit more than just showing, oh, they make money, here's how much they make, here's the guidelines. It's going to require an actual showing of what the child needs, what the disability is, how long the child's anticipated to be disabled. You know, is the child ever going to be able to support themselves? There's a lot of factors that go into it.
And that's really looking at kind of the what's wrong with the child and what's going on with the child and, and what does their future look like?
Yeah, I think there's a lot of that. How can we support this child or individual going forward in their life?
I've seen a lot of litigation coming with that with autism right now, with autistic children that are never going to be able to live outside their mother or their parents' home. And how do you go forward on child support with that? And there's, with autism, there's a large range of the spectrum of autism. So some autistic children might be able to get some sort of a job, but maybe can't live on their own. So that could be considered. And then there's other autistic children that maybe are further down the spectrum that just aren't ever going to be able to work outside the home. So, so I think it requires, at least in the cases that I've tried on adult disabled child support, it requires kind of an extra amount of evidence, which makes them fairly expensive to litigate, to try to prove, those adult disabled factors. Like, I even had one where the child lived in a facility, not even in the mother's home. And the court awarded child support to the mother to support the child in the facility because she still had to pay for some of the child's expenses in the facility. And so those are fairly expensive cases to litigate when you start talking about the discretion of the judge to award the child support above the age of 18 and the inapplicability of the guidelines, because it can be, the guidelines are out the window at that point. It's not just a 20% of, it's more about the needs of the child.
I think you have a good opportunity, too, as a practitioner, to work with a trust and estates attorney who does special needs trusts as you're working to formulate what the structure of the payment's going to be. And because once we're done with the family law side, then your client is dealing with this essentially lifelong. And we have a really good opportunity to collaborate with people outside of the family law field to help benefit our clients the best that we can. And
the family code actually got amended to allow for the child support payments to be made to the special needs trust, because there were a lot of, there's a problem like in the law right there, where if the child has income, then it disqualifies the child from some of the government benefits that might otherwise be available, or some of the facilities and things like that might otherwise be available. And so they amended the statute a couple of years ago to specifically allow, or I guess 2019, September 1st, 2019. right now, to allow for those child support payments to be made into the trust so that they don't disqualify the child from some of the government benefits that they might be entitled to. So that's a pretty important area for people that are in that little zone of child support litigation. So, all right. Well, we have gotten to our 30-minute mark on this segment of the webinar Wednesday on child support war stories. So stay tuned, and we will be back in just a minute with enforcement of child support. Keep in mind that this is a webinar that's aimed at attorneys. This is for continuing legal education. If you're out there watching this webinar and you're not an attorney, we welcome you to watch it. But remember that we are not giving you any specific legal advice. We cannot comment on any specific case or situation without knowing all the facts. So if you need legal advice, this webinar is not a substitute for legal advice. Please seek the advice of a lawyer as to your specific situation and get specific advice to that. Because if you rely on just what we're talking about here, we're being general, we're talking about general legal principles that may not actually apply to your situation. This is for continuing legal education only, and we cannot create an attorney-client relationship just through the video camera. Okay? Thanks.